So she asked me to handle the courtroom. Will the clerk please call the case?
This is Supreme Court Case CRA25-014, People of Guam Plaintiff Appellee v. Vincent T. Tedtaotao, Defendant Appellant. Appearing for Defendant Appellant is Attorney Zachary C. Timenglow, and appearing for Plaintiff Appellee is Attorney William L. Stamps. Panel members consist of Chief Justice Catherine A. Merriman, Associate Justice F. Philip Carbolito, and Associate Justice Robert J. Torres. Attorney Timenglow reserves 5 minutes.
You may proceed, Mr. Deminglow.
May it please the court. Chief Justice Merriman, Justice Torres, Justice Carbolito, good morning. Our argument presented today is first that it was error for the Superior Court to decline applying Adriatico to the motion for resentencing, and second, it was error to deny compassionate release. In discussing the motion for resentencing, the court below wrote that the Supreme Court in Adriatico only found the defendant's 2 life without parole sentences as to his attempted aggravated murder charges warranted correction. The court further elaborated that it declined to apply Adriatico and the evolving standards of decency test. And we argue that it was error to do so. There are many facts in Mr. Tedtaotao's cases that correlate to Mr. Adriatico and his cases.
His age, as I computed it, was 19 years, 10 months, and 8 days. And so did you establish as a matter of law that he was entitled to a youthful offender consideration under Guam law?
Well, we did cite to the Youth Correction Act, and the court pointed out previously that it has never been actually applied, although been on the books for decades. And so when we argue that he is a youth offender under the law, the statute contemplates handling youth offenders in the civil context, not in the criminal context. And that was, we cited that as well in our appeal. As a matter of law, he was under the age of 25, which is what the Youth Corrections Act calls for, and he was charged with the aggravated murder at the time of his arrest and conviction. Though it's never been applied because of other administrative issues, such as the parole board not convening on meeting with rules and having facilities necessary to comply with the statute, nonetheless, he does qualify just as a 19-year-old, 20-year-old man at the time. So, to further elaborate, the court...
As you pointed out, the trial court determined that in Adriatico, we found that the 2 life without parole sentences on the attempted aggravated murder charges were invalid because the Guam law didn't permit life without parole for that offense, attempted aggravated murder. And we vacated those 2 sentences, but did not vacate but did not vacate his other life without parole sentences. So in that regard, the court was stating what was correct. What did you think the court had to do beyond that?
I think we could have rescheduled the matter for experts to be called upon. When this court announced its decision in Adriatico, in short summary, yes, that is what happened. The life without parole sentence for the attempt charge was ordered to be corrected. But the court did give instruction on how to look at the other two how to look at the life without parole sentences for Mr. Adriatico. And the court did announce to look at the evolving standards of decency test, and that still, as far as my understanding is still pending before the Superior Court. I don't think they've gone to an evidentiary hearing or an expert testimony phase of that matter.
So you think it was mandatory for the court to apply the evolving standards of decency test?
Under these
to this
circumstances, yes, Your Honor.
You don't think that it was required for him to first have an evidentiary hearing on brain science and youthful offenders before determining whether it should then order this application or do a survey of societal values to determine the application? So you think both steps are mandatory?
I think, well, just in reading the Adriatico case, both steps would be necessary, I believe, because first we talk about the science behind youth offenses, we talk about the science behind youth offenders, and the developing cognitive abilities of youthful individuals under the age of 25. So we first look at that, and then we look at what Guam has done and continues to do as far as youth corrections and youth offenders. And both of these require searching for expertise. Both of these require some testimony, and that was not taken below. The supplemental brief regarding Adriatico was not outcome determinative when considering that these two hearings, evidentiary hearings, could have been applied. The court could have ordered a briefing scheduled. We could have, there are several other avenues we could have taken rather than just saying Adriatico does not apply. And so there are so many congruencies here between Mr. Tedtaotao and Mr. Adriatico that it was error to not apply it at the outset. That is our contention, Your Honor.
I just want to go back again very quickly on the age, is because I raised whether or not he was, could be categorized, considered a youthful offender. Isn't it that there are other provisions that once you've reached the age of 18 that you become independent, an adult, you can make your own decision, you don't need parental consent? Does that factor in any way in terms of determining eligibility as a youthful offender? I understand the civil statute, but are there authorities in terms of other jurisdictions that you're aware of as to whether or not there's an earlier cutoff age?
That is not a question I have looked at in researching this appeal, Your Honor. If the court requires further briefing, I'd be happy to do it. Nonetheless, here on Guam, the court is aware, 18 years old, you are an adult, and if charged with a crime, you are charged as an adult. However, there is also provisions in the statute that allows for 16-year-olds and 17-year-olds to be charged as adults. But we come back again to the Youthful Offenders Act, and the legislature contemplated that 25 would be a reasonable age to consider that we should still handle these individuals as youths. And so without the administrative follow-up to the legislature's mandate to treat 25-year-olds, 18 to 25-year-olds as youthful offenders, it's just not been implemented. And this court pointed it out in the Adriatico decision, and we simply seek to find congruence in the result as what was put forth in Adriatico. the age of the offense, the age of the offender at the time of the offenses should be considered. And we should be having these experts testify as to what the brain science is, what the cultural norms are. And we should delve into that, and the court just outright declined to apply Adriatico, which we believe is error. Secondly, as far as our appeal, we argue that it was error to deny compassionate release. This federal...
You didn't cite a case that supported the proposition that the court has inherent authority to grant compassionate release, but you said you presented two bases of inherent authority for applying the federal statute to the request for relief. What were those two?
Title 7, Your Honor, the
The
power...
7 GCA 7107H justification?
Yes, Your Honor. And as well as the People v. Ho, the statement from People v. Ho. In searching for corresponding cases, we did search for statutes, or excuse me, other jurisdictions applying federal statutes to a
But
state.
before you go to the federal statute, just in response to Justice Doris's question, but 7107H, the 7 GCA, that doesn't give any substantive authority for such relief. Does it provide substantive authority for the court to grant compassionate relief like other statutes in other jurisdictions, or is that just a procedural statute?
Perhaps it is just procedural, Your Honor. Nonetheless, we're talking about inherent authority of the court. And in searching for authority for applying a federal statute to a state or territorial court, found none.
So does that suggest to you that maybe this is better left to the legislature to consider in the first instance, whether or not Guam should have a compassionate release statute similar to the other majority of jurisdictions in the United States?
Well, Your Honor, that is always in the context of this appeal, Your Honor, and appeals like it. Perhaps it is a legislative arm that should take up the issue. But without the pushing for it in the courts, there is no onus on the legislature to act. And if we see this blind spot in our statutes, then perhaps action can be taken.
But you didn't provide any type of evidence or support that there is a gap in the law because the legislature refuses to act. Could it be that it has not been presented with the opportunity to consider whether this is a policy that it wished to provide the courts with the power to implement?
Well, I'm not certain about that, Your Honor. These issues kind of arose around the same time as COVID. And so around 2020, several of our Guam inmates who are housed in the federal system might have taken up this issue. There's not many of them. Nonetheless, we have our Guam inmates being housed in federal systems, and they are applying for these reliefs that are granted at the federal cases, and they find themselves similarly situated to their cellmates or blockmates, and they are asking for the same relief, and the federal system is saying, we're not holding you. And so this issue is coming up repeatedly, and it's entirely possible that it could be repeated in the future.
But many of these states have compassionate release statutes or have adopted similar statutes or recognized the federal compassionate release provision. Are there any states that have looked at adopting it by virtue of a case law, or?
I have not seen one, Your Honor. Did research that, did not see one. Nonetheless, we do ask the court to exercise its inherent authority to do as ought to be done, to look at how he has complied with the federal statute.
But again, looking at the inherent authority of, you cite 7107H, and, Justice Carbolito asked a very pointed question about whether that was substantive or procedural, and that statute's based on California law, and California has interpreted that to, not permit release once the sentence has essentially started. That inherent power of the court under that statute, it doesn't control anymore over the sentence that has started. So how do we wrestle with that problem if California law, on which our statute's based, might be persuasive?
I'm not certain how we would wrestle with that, Your Honor. And
So what were the other grounds then, if it's unclear that the court has inherent authority to modify the rule? What are the other sections that, or are there any other statutory provisions? You mentioned the case law. What was the?
People v. Ho, Your Honor.
And what is that? Can you mention that case again?
Yes, Your Honor. If the court would give me a moment, I'll try to find a pin site to it.
People v. Ho?
Yes, Your Honor.
Okay.
I cite to it on page 14 of the appellant's opening brief.
Yeah, but again, that references back to 7107 and the inherent powers for the court's exercise of judicial functions, right?
Yes, Your Honor.
So it kind of bootstraps that same argument. What about the court's authority? I mean, the sentence isn't an illegal sentence, but what about the court's authority to reduce the sentence in any other statutory provision?
I have not seen any other authority. I think a writ of habeas corpus for an illegal sentence could also be applied. But nonetheless, we do bring these motions in the Superior Court.
And that's how some state courts have addressed it, is through habeas.
Yes, Your Honor. Yes, Your Honor.
Mr. Aglavan,
The timing law, Mr. Timing Law.
I'm sorry, Mr. Timing. The Organic Act of Guam says that it is the governor who can grant pardons and reprieves. Is that an indication that these types of decisions should be made by the executive branch and the governor rather than the courts?
I don't think it inherently stops the court from taking similar action, Your Honor. But yes, the Organic Act does grant the pardon powers to the governor.
And does the Department of Corrections, through the warden or the director, have any authority to grant compassionate releases or allow inmates to leave the corrections facility in certain instances?
I believe it does, Your Honor. I don't have the citation to it, but I do think that the warden has that authority.
Thank you.
Thank you, Your Honor. I have no further statement at this time if the court has other questions.
Well, if the life without parole statute for youthful offenders, hypothetically speaking, is stricken, go back, and so that provision is is no longer legal, then would the parole board have the power? Something that, you know, C.J. Merriman has alluded to. Here it's the pardon powers and parts of the governor that she had mentioned, but would he be eligible if he's no longer ineligible for parole? Would there be anything, would the parole board have the authority to grant parole in this? I raise that because in the research, there are jurisdictions that have medical parole in terms of it's not styled as compassionate release, but it's similar in it's just the title. They use the word parole, special parole, medical parole. And so would that be something that your client would be eligible for, assuming those facts
In this
materialize?
In this hypothetical that the court presents, yes, Your Honor, I do believe that he has served all of his sentences except for the life without parole. And I think that's the only thing holding him at this time. And so I think he would be eligible for release under parole in this hypothetical.
And so in that case, wouldn't it be advisable that the court proceed cautiously here and just trying to exercise some inherent power or authority that we are not, nothing has been expressed that gives the court that power?
I do understand the court's trepidation in taking the action and the relief requested. But we have this situation where Mr. Tedtaotao and individuals similarly situated are coming with this requested relief. And as far as I can tell, this court has not announced that it is just barred from them. I don't think that we've reached that. And so we do request that relief downstairs, and we think it was error for the court not to grant it.
So would your client be eligible for parole if the life without parole sentences were deemed inorganic as violating our cruel and unusual punishment clause?
If memory serves, Your Honor, I think, yes, he's served his time except for the life without parole. Thank you, Your Honor.
Good morning.
Good morning, Chief Justice, Your Honors, may it please the court. I salute counsel for bringing this and his client for bringing this issue before the court. As the court pointed out in Adriatico, that the compassionate release issue was abandoned and so has not been ruled upon. However, it's also perfectly clear that while it's a good yeoman and zealous effort, there's no authority to do so. In fact, as Your Honors have already pointed out in spades, the authorities all point in the wrong direction in that matter. First off, I think it's important, counsel have mentioned the youthful offender statute, but I think it's important to recognize that 9 GCA...
What about if we use our authority to amend a criminal procedure rule allowing them to come in and look for a reduction of a sentence or correction of a sentence? Do you think we have that authority to do that? You know, there's 100, the trial court can reduce a sentence, and it clearly has the ability to do that within a certain period of time after the sentence has been imposed, even when the sentence has been executed upon. But that is a relatively short time frame in which that can occur.
Correct, Your Honor. I believe it's in a matter of months. I mean, it's a very short time period, you're correct.
Right. So what about the authority to amend the rule to permit a motion that would, or extend the time for certain types of exceptions, like for medical release? Would that be appropriate?
That would...
49 of 50 states have some sort of compassionate release or medical parole, or as Justice Carbolito was referencing.
That's an excellent point, Your Honor, and I think that there is a possibility that you could have a case arise where such would be appropriate. However, even if all 50 of other states, even if every other territory and state had this, if we look, the one thing they have in common is they're all instituted by the legislature. These are legislative acts that have happened. They're not judicial acts. They're not the judiciary setting forth. Now, in the case where everyone else has said, hey, this is where the evolving standards of decency are, and you have to allow this, because otherwise it would be a violation, it would be cruel and unusual punishment not to allow it, on a constitutional basis, this court absolutely has the power to declare that. However, that would take a veritable mountain of evidence and an appropriate case.
Well, that's a separate question. I mean, whether or not the life without parole statutory provision is constitutional or in violation of the cruel and unusual is a separate question as to whether or not Guam law provides for compassionate release.
Yes, correct, Your Honor. It's a separate question. I would submit, though, that the analysis and the answer are exactly the same. Whether or not we're talking about life without parole as the unconstitutional, potentially unconstitutional, or alleged unconstitutional, cruel and unusual punishment, the same would go for the lack of compassionate relief on other grounds. Again, you would have to go through, I believe the court would have to go through the same level of analysis to make that type of constitutional determination. As to merely amending a procedural rule, that's going to fall squarely within a separation of powers analysis that Your Honors are well equipped to handle. I'm not going to venture is to tell this court what it can and cannot do. What I will say, though, is that, as this court pointed out in Adriatico, that this court has the inherent authority over prior court orders to substantively change those orders. So there's certainly, I think, some wiggle room for the court to do something in that regard. However, to just carte blanche say, all right, we're going to do what everyone else has done by statute, I would suggest that might be
I don't think
a bit
that's
further
what
than you would want to
I
go.
don't think that's what Justice Torres is suggesting. I mean, if other jurisdictions provided by statute, that's one thing, but if the court was to enact its rulemaking authority to amend its rules and establish a procedure under our criminal procedure provisions, then, you know, what is to prevent the court from doing that? If it may not help Mr. Tamilo's client in this particular case instantly, but if there is a clear procedure that is authorized, if the gap is, even after it's brought to the attention of the legislature and they decide as a policy decision they don't want to address it, then maybe there is a rationale for the court to investigate its rulemaking powers. The research that I'm aware of, New Jersey has done that. It's the only jurisdiction, I think, that provides for a compassionate release, something similar to that through its rulemaking procedure. But you know, in this particular case, I don't know necessarily if that's a remedy outright without clear delineations that is provided beforehand.
Very good point, Your Honor. As a New Jersey Bar attorney, that's correct. However, I would circle back to the process of all the things that would need to happen for this court to do that. It would be a process, as you set forth, to consider evidence, go over things, and then make a prospective rule that could apply. I mean, now, one thing on that is that counsel had also suggested, well, there's a need to act because the legislature hasn't acted. And courts have a solution for that. That solution is you decide the case, the court decides the case that's before it, and then states, the legislature hasn't ruled on this one way or another, and the legislature needs to act. Barring the legislature affirmatively stating or affirmatively denying, this court lacks the power to do so. I think that the Ho case that was cited is very clear on that, and we highlighted that in our brief. The judicial power is accepted and generally held to include more than merely deciding cases, but the doctrine of inherent authority is, quote, still viewed as a limited source of power in matters where the legislative branch failed to fully provide. Here, where the legislature hasn't provided for that, I think the amount of space left to the court is limited.
I'm skeptical about the inherent authority, but in terms of the rulemaking authority, we have pretty broad rulemaking authority on criminal procedure matters under the Organic Act. And New Jersey adopted a criminal rule that, as Justice Carbolito pointed out, there was also a short time frame in which you could file a motion to reduce a sentence, but they set forth enumerated exceptions to that rule and allowed for release. One of the exceptions was amending a sentence to permit an offender or the release of a defendant because of illness or infirmity. So essentially creating, by modifying the criminal procedure rule, a process by which someone could seek. I mean, the idea is to address the merits of this, not put up barriers towards resolution of some of these issues. And there are good reasons why 49 of 50 states have adopted release provisions for prisoners under certain circumstances. I mean, we're not talking about opening the floodgates. There have to be very strict criteria that's issued. And so New Jersey did that. And so while I'm a little skeptical of the inherent authority, I think the rulemaking potentially provides an avenue for the court to examine.
Absolutely, Your Honor. And within that, that's what I'm just as the court is usually reluctant to provide prospective, non-adjudicative advice, I would be hesitant also, but I don't see anything in either one of your analysis that would point in any other direction, other than a couple of things to consider, specifically as it applies to youthful offenders. The legislature has expressly already spoken to this issue, which is one of the reasons why I think a decision is necessary as to the specific case. 9 GCA 83.15D, while it does define a youthful offender as between the years, at least 18 years of age and under the age of 25 at the time of conviction, in the last sentence it says, quote, it shall not mean a person convicted of an offense punishable by life imprisonment. The legislature has already determined and stated in that statute that the defendant in this case is not considered a youthful offender.
Yeah, but then that would have been true for Adriatico as well, right? So we remanded in Adriatico for the court to conduct an evidentiary hearing on brain science and youthful offenders. He had been also given a life without parole sentence.
Yes, Your Honor, with one key difference, which you pointed out earlier, which is in Adriatico, we are dealing with an attempted murder charge or attempted aggravated murder. Here, we have an aggravated murder charge.
No, we had both in Adriatico. Adriatico had the attempted ones were vacated because it was illegal to impose the sentence, but there was also, he was convicted on a separate murder charge with life without parole. So it wasn't just an aggravated issue.
And yes, Your Honor, what I saw on Adriatico was that the line was that it was expressed and that the trial court brought to light was that they didn't feel Adriatico applied because here we were dealing with aggravated murder and the law did provide for that sentence. So I think that's different. As to the attempted aggravation, sure, that applies square on. But as to the actual aggravated murder charge, in this case, that does not apply. As to whether or not the defendant would be eligible for parole, I think, we can do the math, but I'm going to my napkin math says no. Not just because because some of these, we had attempted aggravated murder, we had aggravated murder, we had other charges that were involved too, plus multiple escapes, all of which had, I wasn't quite sure how the individual in question, maybe it was a felony on felony release situation, was somehow convicted of other charges. I think we had, oh yes, robbery, kidnapping, burglary, terrorizing, felony escape, in addition to those others. But given the wide range of sentences that this individual received, I don't think that this individual has served their time yet, even if the court were to incline to grant that.
Should the court have, in light of our decision in Adriatico, shouldn't the court have gone forward to order the trial court to hold an evidentiary hearing on brain science and youthful offender for Mr. Tedtaotao?
My understanding is that the court is in the process of doing that with Mr. Adriatico. It has not happened yet, but is in the process of doing that. And one of the difficulties with that is in locating the experts, holding the evidentiary trial, et cetera.
Right.
And that's one of
I know it can be time consuming and, obviously you have to find the right people, but the complexity and impediments to holding a hearing doesn't address the question of whether a hearing should be held. That's a different question.
You're correct, Your Honor. It doesn't. It does highlight, though, that I think Adriatico is something that this court made that was, let's say it was an aggressive decision, and those provisions might be provisions that this court, upon reflection, might find not to be the way that it wants to continue. Holding a trial of that an evidentiary hearing of that magnitude for each youthful offender, even if they don't qualify by statute to be a youthful offender, merely on the basis of age and for Eighth Amendment considerations, our office respectfully submits that that's.
But it's not every youthful offender, it's those with life without parole sentences. And so I don't necessarily, obviously I have nothing anecdotal about the number that might be encompassed within that time frame, but I would not expect that it would be a significant percentage of the population.
That might be the case, Your Honor. People would respectfully submit, however, that that's typically the type of fact-finding that's best done by a legislative body that can do the research, hear testimony by experts, and then come to a considered decision on what makes sense. Doing this under the guise of an Eighth Amendment is, as I suggested, perhaps a little aggressive.
Yeah, but Adriatico is now the law of our jurisdiction. And if Mr. Timing Law has made a showing that under Adriatico, his client is eligible for consideration that under the new test that we have announced, then shouldn't the court have at least considered an evidentiary hearing to determine whether or not Mr. Timing's client is, number one, eligible, number two, whether or not the science and the test that we announced in Adriatico must be applied, and how is it to be applied? And where we were leaving that to the trial court to decide in the first instance.
You're correct, Your Honor, and I think that's the key point, is this court gave, quote, "It is within the trial court's discretion to order briefing or hold a hearing to establish the objective indicia of societal values." Now, in this case, there was a hearing held, there was testimony held, and that was provided, and the trial court reached its decision. This court's well within its power to say, we don't think they did enough. Trial court should
No,
have done.
that's not my understanding of the record. My understanding of the record is the trial court distinguished that we applied Adriatico to the attempted aggravated murder, and he was convicted of aggravated murder, and therefore Adriatico didn't apply.
First, Your Honor, the court did hold briefing, so the issue was briefed below. Second, during that briefing process, there was a hearing held, testimony was given. My understanding was that testimony was provided on the issue, and the court made its ruling. If this court doesn't feel like its counsel was followed and the court didn't do enough to follow the direction, then the court should issue a directive. However, we would submit that the briefing and the hearing that was held was sufficient in this matter. As to, moving on, just briefly as to the issue of compassionate relief, I know this was already largely discussed, but just to make it very clear, here we're talking about applying federal statute and having that federal statute be applied by state laws. I respectfully submit that there's a reason why there isn't any case law on that, and that's because states are universally reluctant to enforce federal law, and there are good reasons for that. In fact, there is case law that the federal government cannot force, Lopez and other cases, can't force the states, can't co-opt them into enforcing
I think the argument is that the federal statute provides standards, and that if the court exercises its inherent authority, it can consider those standards in determining whether or not compassionate release is warranted in the particular case. Not that the Superior Court would enforce a federal statute because it's applicable to the court. I don't think that was the argument.
Well, I think that effectively that is the argument, saying let's take this federal law and let's have our local Superior Court enforce it. Whether or not it's called enforcing the actual law or just using it as a guideline.
If the Guam Supreme Court was to consider utilizing its rulemaking authority and looked at the federal statute and saw that the provisions there make a lot of sense for Guam and decide to adopt the provisions in its criminal procedure rule, what's to prevent the court from doing that?
As discussed earlier, to prevent this court from doing that, I'm not aware of anything that would prevent this court from doing that. However, here today, we're talking about what the Superior Court did or didn't do, and the Superior Court did not commit any error of law in holding that it lacked jurisdiction, it lacked the power to enact, basically, the federal compassionate release statute in Guam's courts. It doesn't have that power. It doesn't have that substantive power. The power that you outlined, Your Honor, would be procedural in nature within the court's rulemaking authority. And that's an entirely different matter.
Thank you.
The court has no other questions.
No.
The people
Chief Justice, do you have any further questions?
My only question is, a lot of your comments about the Eighth Amendment make it sound like you don't think that's an important constitutional provision that we should be concerned about. We have a comparable provision in the Organic Act, and it gives certain defendants rights. Don't we have an obligation to uphold those rights?
Absolutely, Your Honor. It is this court's sacred duty to uphold those rights. And my apologies if I seem to, any comment or anything I suggested was such that to the effect that those rights aren't important. However, the process that's involved in looking at those laws is involved, and I'm suggesting merely that for the people that that procedure hasn't been followed in this case, and there is no evidence, there's nothing to suggest that it rises to the level of cruel and unusual punishment to convict someone between the ages of 18 and 25 to life without prison for aggravated murder.
Thank you.
Thank you.
Accordingly, the people respectfully
you.
submit that the trial court's decision should be affirmed. Thank you.
Mr. Taminglo, I believe you have 8 minutes.
Thank you, Your Honor. I'm happy to hear the discussion that was happening during the government's portion. I don't have any further comment unless the court has further question.
I don't have any further questions. Chief Justice, any further questions for Mr. Taminglo?
No, thank you, counsel, for your argument.
Thank you very much.
Thank you, counsel. The court will take the matter